Trotter.
Good morning, Your Honors, and may it please the Court. I'm Aaron Trodden on behalf of Isaac Martinez Chavez. The disputed issue at trial in this case is whether Mr. Martinez Chavez knew there were guns in the car he was driving. The district court made two related errors that weighted the scales improperly in the government's favor with respect to this issue. First, it permitted the government to make improper argument in closing, and second, it refused to give an adverse inference instruction based on the government's spoliation of evidence. With respect to the government's improper argument in closing, the government agrees that by calling Mr. Martinez Chavez's sole witness, Olman Vallejos, a liar, and by arguing that the this case was important to law enforcement, and that they were professionals who were protecting the community, and to that end, the jury should convict. The government made improper arguments, and as to the liar comment, that they were plainly so. These arguments deprived Mr. Martinez Chavez of a fair trial. They were.
Can I just ask on that point? Maybe that doesn't matter because they've agreed to it. It strikes me as odd in this scenario where the person being described as a liar was an admitted liar, like everybody acknowledged he was a liar. He said he had lied. It seems odd to not be able to say that he was a liar. I presume you would think it would have been fine if they said he admitted that he lied, or that everybody saw that he lied. Why do we think the use of the word liar, which seems to be exactly the same idea? I mean, I know our courts, we have said this before, and the government's admitted it, and so I don't want to belabor it, but it seems particularly unusual in this scenario where there wasn't a debate. I mean, most of the cases where we have this come up, you know, it's like the government's suggesting that they're a liar based on inferential evidence, but like, there's not a dispute that he was a liar.
I think there was a dispute that he was a liar. I think there's a very different valence between liar and confused. And I think certainly counsel recognized that he was not an ideal witness. I did meet or I didn't meet? Like, you think he was confused about that? As I pointed out in the briefing, it's unclear whether he understood what was meant by the defense team. And I don't want to belabor this either, because I do think that this is beside the point now that the government has conceded this. But certainly, no one admitted that he was a liar. This court has recognized that the liar comment is problematic. Liar has a very different valence than simply saying the witness is confused, or the witness has difficulty remembering, or the witness is not credible. And I disagree with you.
Do you think it would have been proper if the government had said, as I sort of took the defense lawyers to say, that the witness lied?
Yes.
You think that is also improper?
Yes. This court has recognized that that's improper on multiple occasions. And the reason that it's improper is because saying that a witness is a liar on the stand is very different than saying this witness isn't credible. It's accusing the witness of committing a crime. And in fact, the government explicitly did that in argument here at JA 1168. Regarding Mr. Vallejos' testimony, they said, that's what we call perjury. That's lying under oath about an important matter. Now, this court has recognized that one of the concerns that arise when the prosecution calls someone a liar is the inference that the prosecutor has information that's outside of the jury's knowledge.
Is that concern really present here? And I understand what you're saying about the government conceding that this was improper, but some of the same issues show up in whether it really had a tendency to mislead the jury. And given the context, it just struck me that the most obvious inference by kind of a mile would be that the prosecutor was referring to what the jury had just heard from this witness.
I think they are, but I think that's what we call perjury. We, the government, we who are aware of such things, we who are in charge of law enforcement are looking at him, and we're telling you that man committed a crime right in front of you, and you members of the jury are witnesses to it. The other reason that this is problematic,
Wait, why is that? Tell me why that's problematic. I mean,
because
except for a second that it's true that he lied about a material matter, and that is indeed perjury. Like, why is that, taking it, as Judge Harris correctly puts it, in the why this, misinforms or misleads or misinfluences, to make up a word, the jury? Why is that what seems to be a very truthful statement to me, that he did lie, it was about a material matter, and that is, under law, whether you're law enforcement or a defense lawyer, that's called perjury.
Courts have recognized that the jury is the one who makes that decision, not the prosecutor. The prosecutor doesn't get up.
No, that's just like a statement that we call lying about a material matter perjury.
I would disagree with that, Your Honor. Maybe that's a problem because I'm down here and you're up there. But I think that there is more to perjury than that. And I think that, as I briefed, there are certainly concerns about how much Mr. Vallejo stood and how understood and how confused he was. But the other problem with the government's statement is that they are tying what Mr. Vallejo said to the defendant. Mr. Vallejo was the only defense witness. And what the government argued was there are only two people who know whether Mr. Vallejo was in the car. One of them was Vallejo, the liar, and the other person is the defendant. So not only is the government arguing, that's at JA 1172, not only is the government arguing that Mr. Vallejo is a liar and a perjurer, which is improper under this court's precedent, but also that the defendant, Mr. Martinez-Chavez, is implicated in that. They're drawing a direct line between him and Vallejos and essentially accusing him of being part of that and implicating him in that. And that is also prejudicial. As the Fifth Circuit said in Garza, you can't throw a skunk into the jury box and expect the jury not to smell it. And I think this is the skunk in the jury box. Part of the problem...
Wait, but is that a reference to the statement, or is that a reference to calling someone who was a liar?
I think
who's throwing the skunk?
The government's...
In that example?
Excuse me, Your Honor, I'm sorry.
In that example, who's throwing the skunk?
The government, Your Honor. By calling him a liar and a perjurer, and by linking those crimes to Mr. Martinez-Chavez.
It's kind of like, if I understand your argument, the way I see it, is that a person who lies, and you lie, but to call someone a liar is to say more about who they are. Like, for example, a person could have a criminal record, but then they say, he's a criminal. Well, he said, that's true because you did commit a crime. Yeah, but to say a person is a criminal carries a different meaning than it was. I understand your argument, that it's basically you're branding the person that said you're a liar, meaning the truth is not even in you. That's what,
Exactly, Your Honor. And I think the other reason that these arguments have such sting is with respect to Mr. Vallejos is because he isn't a perfect witness. Because the jury is having to hear his testimony and think, what do we make of this? Does this get us to reasonable doubt, which is really what they have to determine here? And by arguing that he is a liar and a perjurer, and that not only is he, but that the defendant is implicated in that, the government tips the scales. The government pushes this over the edge in a way that is prejudicial to him. Now, the other prejudicial comment, and this is the comment that was objected to, was the argument that this was important to law enforcement, that they were professionals, and that the jury should consider their protection of the community and in convicting Mr. Martinez-Chavez. And this is improper and prejudicial in several different ways. First, the fact that it may or may not be important to the law enforcement officers is of no moment whatsoever to the jury. It's completely irrelevant. There's a false equivalence that the judge applies between well, it's important to the defendant, it's important to the government. But the defendant has constitutionally protected interests here. The government doesn't. And asking the jury to consider the importance to the government is a little bit like asking the jury to consider that the government thinks this guy is guilty or that the government has indicted the defendant. Similarly, the protecting communities comment or argument raises the same concerns that this court has articulated in other cases where the jury is being asked to make policy decisions and to consider the case based on factors outside of the evidence in the case. And I think particularly difficult here as well is the professionals comment, because the issue in the case really related to whether or not the officers, and especially Officer Hilton, because he's the only one there for all of the significant events, whether his testimony and whether his recollection of these events was reliable. Saying that these officers are professionals is equivalent to saying these guys know what they're doing. They would not make the mistakes that the defendant is alleging.
In connection with that, can I ask you about the district court's curative instructions? Because I think it was during this colloquy where the judge says, I will be giving curative instructions. And the judge does instruct the jury, make your own credibility determinations, and in particular, do not give the testimony of law enforcement officers any special weight. And we have held in the past that that kind of somewhat generic instruction can do the trick. So why doesn't it resolve the concern here?
For two reasons. I think generally the fact that it's a general instruction rather than a particular instruction in response to this comment matters. More significantly, the jury understands that the judge is going to rein in the government when the government goes astray in closing, because that happened earlier, where the government made an improper argument and essentially testified, defense objected, and the government immediately, or the judge immediately reined in the government and said, prosecution may not testify. That didn't happen here. The objection was overruled, and the government...
I do understand that point, and you make that point in your brief too. It just seems somewhat counterintuitive. Like if the defendant had lost all of his objections, then we would have less of a problem. But because the district court, totally on the mark, is sustaining some of the defendant's objections, that means this becomes more prejudicial. That it kind of weird incentives we're putting out into the world.
I think that it would still be prejudicial. I think I would be making the same argument because I do think the fact that the district court didn't correct it at the time is problematic, that it was not targeted at this particular comment when it was subject to an objection. I understand what your point, that it is about the incentives, but I do think as a practical matter, that's what the jury is taking from this. If we see the court correct the government on one point and not on another, we assume that the other point is fine and worthy of the jury's consideration. One other point with respect to the improper arguments, and that is that the government relies heavily on the strength of their case otherwise and contends that none of this matters because the government's case is strong otherwise. Courts, though, looking at these cases where they have generally found that despite the improper comments, the case doesn't merit reversal, in all of the cases that the government relies on for that, there is independent evidence that the court is relying on, apart from the bolstered law enforcement testimony or the challenged credibility testimony. For example, in this court's decision in Lopez, the proof of guilt centered on independent DNA evidence, and the improper comment there didn't really change the situation. In this court's decision in Woods, where the defendant was accused of lying under oath, the court said there's plenty of other evidence, competent evidence, apart from this testimony. In the court's decision in Craddock, where the government vouched for government witnesses, the court noted that many other witnesses, apart from those witnesses, could say that the defendant possessed a gun.
But it's not, or is it disputed? I thought the evidence here is that the defendant is the driver and only occupant of the car with the gun in plain view. I mean, doesn't that count as independent evidence, or is that disputed?
Well, it's not disputed that
Okay.
he was the driver of the car and that the
And
guns
only
were there.
occupant and the gun is there.
I see my time is up. May I respond?
You may.
Yes. First of all, the government didn't rely solely on that. The government pointed to all of this other evidence that.
But I mean, that evidence is unaffected by I mean, it is independent evidence.
It is independent evidence, but it's not very strong independent
Okay.
evidence, especially given the testimony of Mr. Vallejos. This is in some ways akin to the Fifth Circuit's decision in Aguilar, which was the case involving the ambulance with the hidden compartment full of marijuana. The law enforcement agents testified that the defendant had confessed. The defendant said he hadn't confessed. There was some other kind of circumstantial evidence in that case that suggested that he might have known about the marijuana, but the Fifth Circuit ultimately said that evidence doesn't carry the day. When you take out the disputed confession, the rest of this isn't sufficient. And we would argue this is a similar position. Thank you, Your Honor.
Thank you, Mr. Charlie. Mr. Jones?
Good morning, Your Honors, and may it please the Court. My name is Jonathan Jones, and I'm here on behalf of the United States. Your Honors, I'd like to start with the issues related to the closing argument and then move, if possible, to any questions related to the adverse inference instruction that was requested by the defense here. Beginning where my opposing counsel ended, I want to talk specifically about the evidence in this case and the fact that there was straightforward and overwhelming evidence of guilt, even if you set aside the statements from Officer Hilton from the earlier part of the traffic stop. What we have in terms of evidence that is largely undisputed are the facts that Judge Harris, you mentioned. Specifically, it was Mr. Martinez Chavez's car. He was the only occupant in the car. There was a gun in plain view on the floorboard.
He was the only occupant when the car was stopped, yeah.
Correct. He was the only occupant when the car was stopped, but in addition, the photographs in the body cam made clear that the car was full of other stuff, such that nobody could have been sitting on that front seat. It was covered with tools and a battery charger, indicating that there was nobody else there. In addition, they found two .22 caliber firearms in the car, and in the center console, there was .22 caliber ammunition that their alibi witness never claimed. Beyond that, we have the statements from Mr. Vallejos himself, and these are captured on the body cam, where his door is open, somebody comes out of the house, and he is begging that person to close the door. So when you put all of that together, even when you set aside some of the earlier testimony from Officer Hilton, which I'll point out is corroborated by other evidence as well, there's clear and straightforward evidence of his guilt in this case. So when we take that as a starting point, and we look here and we see that we have a straightforward and overwhelming case of guilt, and then that their only alibi witness was frankly incredible. Now, we have acknowledged that it was improper to call him a liar. When we look at the context of how that statement arose.
In your case, it's interesting. You just gave us a scenario that what I would call colloquially the close and shut case. Then why is it necessary to call him a liar? I mean, you represent the United States. You're able counsel. You have this ironclad case. Why do you try to put a cherry on top and to say that he's a liar? I don't understand that as an officer of the court and prosecuting these cases. Why is that necessary?
Your Honor, it was not necessary here for the prosecutor to call him a liar. I think we acknowledge that. We certainly admit that that was improper. That was a step too far.
So counsel, I mean, I guess building on Judge Gregory's question, we have been so clear about this, you know, whatever else you do in a closing argument, just don't call the defense witness a liar. And I do have a concern that if we don't eventually enforce that rule by reversing a conviction, it's just, I mean, it becomes kind of meaningless.
Your Honor, I have a couple of responses to that. First of all, I will point out that under this court's prior decisions, the question here is not how do we punish the government. The question here is whether Mr. Martinez-Chavez's rights were violated, and specifically whether the outcome was going to be different.
Well, I
if
agree
he had-
that is a big question in this case, but I do have a concern about whether our repeated opinions establishing what ought to be a very easy-to-follow, bright-line rule, you know, at what point they stop being meaningful.
Your Honor, the other thing that I will point out is that the last case from this court where it rules on this question, at least as far as the parties have cited it and as far as the government has found, is from 2013. So that's roughly 13 years ago. This is not an issue that's being litigated every session in front of this court. In the thousands of cases that are tried within this circuit, this is not a routine problem. If what we're seeing here is that once every decade we have a prosecutor that takes a step too far and says liar when he shouldn't say liar, then I don't think that this is a problem where the court feels the need to specifically go out and punish the government to try and rein it in. I think what the court needs to look at here is the specific question that's been laid out in its prior precedent, and that's specifically, was this actually prejudicial to Mr. Martinez-Chavez? And when we look at the entirety of the context here, it's an open and shut case. It is clear and straightforward that he knowingly possessed the firearm. His only alibi witness is somebody that was not credible. And again, you don't have to take my word for it because the district court specifically made that finding during sentencing. She specifically said, I do not find him credible, and that would not be a surprise. That finding is not a surprise to anybody that was in the courtroom. So
That finding is not a surprise at all in any case. Many times the trial judges make decisions as to credibility. That's all the time. There's nothing rare about that at all. But the fact that you equate lack of credibility or finding of not credible to being a liar, and that's the problem systemically. If you don't get that lesson, and it's not, you're going to be right in the same place. Oh, the judge said you're not credible, so that equals liar, and it doesn't, does it?
Your Honor, I don't necessarily, I don't agree that
No, wait, stop right there. Does it?
liar does not equal lack of credibility. I agree with that,
No,
Your Honor.
vice versa. I mean, in other words, being not credible doesn't mean you're a liar.
I agree with that, Your Honor.
Right.
I think that's right, Your Honor. And that's why we agree in this instance, the prosecutor went a step too far. But the fact that he was not a credible witness is important for this court's determination of whether there was actually prejudice here, whether there was a tendency to mislead, whether the outcome would have been different had he not been called a liar. And I want to be clear, both with respect to the liar comment and with respect to the other comments about this being important to the government, and the fact that the officers are professionals. If you remove all of these statements from the closing argument, these handful of 4 or 5 sentences from 21 pages of closing argument, and you have the rest of the evidence that came into this case. You have the rest of the arguments made by defense. You have the alibi witness testimony from Mr. Vallejos. There's no reason to believe that the outcome is different because the evidence is overwhelming. And
Here
because
again, you're saying the outcome is overwhelming. Now, why then do you need it to, we used to call it leaning on the shield? In other words, well, let me make sure now, you know this is important to law enforcement. And basically what you're saying that not finding guilt here is undermining what and I agree, our brave and very heroic officers every day that protect us do. I agree with all those statements. But is there a place to sort of say, now that ought to tip even more why you shouldn't bring back a verdict that's inconsistent with supporting that? That's basically what that means. Did I get anything wrong in that?
Your Honor, I think that's a fair characterization of what the prosecutor here said, and we agree that that was a step too far. That's not something that he should have said, and that was improper here.
So can I just ask about that part? I mean, I think there are things that are improper. I wonder about that part, though. Was there an instruction? I don't remember in this case. Was oftentimes, at least in my experience, district court judges would include in their instructions in criminal cases something to the effect of, this case is important to the government for enforcing laws as a primary responsibility, and the case is also important to the defendant because he's been charged with a serious crime. That was a sort of standard instruction, at least in some federal district courts. Was that instruction given here? And do you think that such an instruction would be improper?
Your Honor, that instruction was not given here, or there was no instruction similar to that given here. In response to the second part of your question, I would want to see the specific language of any such instruction. I would have concerns to the extent that the jury is specifically being told that they can consider, or if anything, suggests to the jury that they can consider whether or not this is important to the government as part of their calculus in finding guilt. Now,
Well, but as long as the point would be, I mean, that instruction sort of says, listen, this is a case that's important to the government, it's important to the defendant. Like, so you have to decide it. It's not about who it matters to more, it's about what's before you. It seems like that's not what was done here. I'm not suggesting that, but it just struck me as like a common sort of instruction that I've heard, and this is just like given half of it, I guess.
And Your Honor, that instruction was not given here. There were instructions specifically about counsel's argument not being evidence, and specifically that law enforcement witnesses are not entitled to any additional credibility. With respect to, I think, the way that you've described instructions that are sometimes given in courts, I think that what that makes clear here is that there was no tendency to mislead and that there was no prejudice here. The court, in ruling on the request for this, the request for the instruction, said specifically, it's important to the defendant, it's important for the government, it's okay for the jury to understand that. Whether or not that's right, that's something that a jury is going to recognize anyway. The jury, seeing that the government has come in, put in this effort to try this case, they recognize that it's important to the government, they recognize that it's important to the officers. So there's not a reason to believe that it's going to start tilting the scale in terms of what happens in this case. And that's especially true when we have a case where the evidence is very straightforward. Your Honors, unless there are any additional questions specifically on the closing argument issue, I'd like to transition to any questions related to the spoliation instruction and the request for an adverse inference instruction from defense. To begin, Your Honor, in the reply brief, they frame their argument very specifically in terms of Jenks, and I want to be very clear about our position here. This was never something that was in the government's possession, so it was not something the government would have had an obligation to produce under Jenks. Now, looking specifically at Johnson, we've taken the position that this specific portion of Johnson is dicta. But even if we are applying Johnson, the two prongs that it sets forth are not satisfied here. First, there's not evidence that the government knew that this was relevant to the defense. It was redundant of other evidence. There was not a way for that. They did not recognize.
Can you tell me what you think? Assume for a minute that either Johnson's dicta or it doesn't exist. Either one doesn't matter to me.
Yeah.
What do you think the correct standard ought to be in a criminal case? I mean, if we were looking at a criminal case and we were not trying to parse language from that prior opinion, I'm not trying to throw away, Supreme Court precedent, but what do you think the standard should be? I mean, do you think it's ever possible in a criminal case to have a spoliation instruction? I assume the answer to that is yes.
The answer is yes, Your Honor.
Okay, and then secondarily, what do you think the right standard is? And maybe start with non-electronically stored information, and then tell me if it's different if it's electronically stored. So if it's a piece of paper, start with that example, and then if you think it's somehow different for electronically stored information, and tell me why. Your
Honor, I think that the relevant standard would need to come from the Supreme Court's decisions in Youngblood and Trebetta, which set out what the due process clause requires in this instance, and then from Rule 16 in Jenks and what is required there. So, for example, if there was a situation under Youngblood where the government had acted in bad faith in destroying evidence or losing evidence, then in that situation, you could get what I'll call sort of a standard spoliation instruction that the jury can infer that the evidence, had it existed, would have proven the point of the person that wished to offer it.
So if there's a due process violation, whether that's Trombetta or Youngblood, then your point is the district court has some authority to dismiss the charges as a result or to give an instruction.
Correct, Your Honor.
Is that it? Is there anything short of that? So imagine a court said, I do not find Youngblood or Trombetta, the sort of dual standards, satisfied here for one reason or another. Is that the end of the game? Is the spoliation limited to due process violation?
Your Honor, I think the answer to that is no, but
Okay.
it would need to come from a violation that stems from either a failure to abide by Rule 16 or a failure to abide by Jenks. In other words, it would need to come from a specific discovery obligation that the government has. So if the government failed to abide by Rule 16 and ended up destroying evidence that it had in its possession, it was obligated to produce under Rule 16. In that situation, the court could consider whether a spoliation instruction...
Is that coming from the idea that in order to get a spoliation instruction, there has to be some duty? And that duty might come from Youngblood and Trombetta, right? But that duty might also come from somewhere else. But your question or your answer seems to suggest that what we're really looking for is the violation of some existing duty that would be necessary to create a spoliation.
I think that's right, Your Honor. I don't think that there would ever be a situation where a spoliation instruction is appropriate if there wasn't a prior pre-existing duty to provide that. So to apply that specifically to this case here, the government never had these materials in their possession, and so there was never a duty to provide them. I want to be clear, the government had no objection to providing them. As soon as defense counsel asked for them, government the next day reached out to the Franklin County Sheriff's Office and tried to get them. Unfortunately, at that time, they had already been destroyed. So the government would have been happy to produce these. But what is significant for our purposes here is that there was never a duty to collect and produce these. There's never a duty to sort of preserve, collect, and produce these.
And then if there was a duty, and this might not be terribly relevant here, but I'm just curious, and you think about this a lot, so I'm asking. And then if there's a duty, you would agree it doesn't require bad faith, but it requires something more than negligence to get such a spoliation instruction, right? So in other words, if there's a duty and you had it and it was destroyed, if it was an accident, that probably, I assume in your mind, would not give rise to a spoliation instruction. But on the flip side, you don't have to show that it was destroyed with the purpose of depriving the defendant of the evidence, at least if it's non-electronic. Is
Your
that
Honor,
fair?
let me respond to that question this way.
Sure.
To the extent that there is a due process violation, a spoliation instruction may be appropriate.
Yep.
To the extent there's a situation where the government has a duty to provide something and fails to satisfy that duty, I think we acknowledge that there are situations where an adverse instruction may be appropriate. I'm hesitant to sort of opine specifically on what state of mind the government would have needed to have in order for a spoliation instruction to be appropriate. I think that's something that may depend on the specifics of any particular case and what is necessary in that particular case to ensure a fair trial. I'm not aware of either Supreme Court precedent or specific precedent from this court on that particular context where Rule 16 evidence, for example, is not turned over. And so I'm not prepared to say specifically what the standard would be. But
It's not. That's why I'm asking, right? And I understand. You can say, I don't know. That's a perfectly acceptable answer. People are very hesitant to do that at the lectern. I'm happy for you to say, I don't know. I just was curious if you had a thought about it.
Your Honor, I'm happy to take that invitation and say I don't know specifically what the standard would be there. What I want to make clear for purposes of this case is where there is no pre-existing duty, the spoliation instruction is not appropriate here. And to the extent that the defense relies exclusively, and that's how I read the reply brief, exclusively on Jenks, Jenks does not apply here because the government never had this in its possession. The statute in Jenks is very, very clear about what is required, and because it was not in the possession of the United States, there was no Jenks obligation to produce it. And then once we go through the rest of the Johnson analysis, even assuming it applies, and we've argued that it does not, those two prongs are not satisfied.
Can I ask you just a question about how this issue developed during the proceedings? Am I right that before, and I can ask your colleague this too, before the district court, the defendant's argument was a little bit different? It was that this was actually willful misconduct, I guess, that there was a willful choice to preserve some forms of evidence, but not this form of evidence. And the district court said there was no support for that. Is that?
That's correct, Your Honor.
And then we got to the Jenks theory.
That's correct, Your
Okay.
Honor. So Jenks was never raised below. What
Okay.
they said is that the Franklin County Sheriff's Office there's a protocol, there's a policy. Under that policy, certain things can be selected for longer preservation. That was not done here, and it should have been, and that was a willful violation.
Okay.
The court rejected that argument below, and we think this court should reject it as well.
Okay.
And from there, you said that you had no duty. Why? Because you don't control the sheriff's office? Why is it you had no duty?
Specifically as to the audio recordings, Your Honor?
Yeah.
So the reason that we would not have had a duty is that they did not fall within Rule 16. They did not fall within Jenks because they were not in the possession of the United States. And there's no due process violation here, which is something that defense counsel acknowledged below. They admitted that there was no bad faith and that this was not exculpatory evidence. In fact, we think it was most likely inculpatory evidence. But because there's no due process issue, and because it was not something that fell within the scope of Rule 16, and it was not something that fell within the scope of Jenks because it was not in our possession, that we didn't have a duty to collect and produce it. In Youngblood, the Supreme Court made very clear that there is no freestanding obligation to preserve, collect, and produce every piece of evidence that might be of sort of conceivable relevance. And so we want to be...
This is not that type of evidence. This is not one of those things where it's far-fetched, right? Because this will be very helpful, because the key to this case in terms of the offense is, was there a passenger in the car? And that passenger said, yes, I was, and that was my weapon. So this is not some ethereal type thing here, right? This is the piece de resistance, as the French would say.
I don't think it's far afield, certainly, from the critical evidence in this case, but what I want to be clear is that when you look at the evidence in this case, even if you set apart all of the information that could have been gleaned from the audio recordings, all of the elements necessary to convict were there. The government had clear, straightforward evidence about the knowing possession of the firearm. And even if you consider the sort of specific pieces of Officer Hilton's testimony, even aside from the audio recordings of the dispatch, those were otherwise corroborated at trial.
Was it impossible to sit on the passenger seat based on how high the power was of tools?
Your Honor, I can't say that it was impossible, but I think it was very unlikely.
I know the answer, you can't tell, but you probably could. Now, one may be uncomfortable, but it wasn't. My point is, you could sit there, physically sit there, and normally you would say, that would be a strong argument. It's unlikely. But you have a witness who said, I was there. And I know you called him a liar and those kind of things like that, and that nobody should trust him and that kind of thing. But, you know, so it is what it is. But the whole surround, wasn't there some question about communication, whether someone said that, made some comment about whether or not that somebody was in the car or whatever, that the audio that may have helped?
So the three issues, the three pieces of evidence that came in that, as I read the record, the defense counsel was trying to oppose with hopefully the use of the dispatch audio was, one, that Mr. Martinez-Chavez was in fact speeding, two, that he turned the lights off in his car, that he blacked out his car as he was driving, and three, that he reached over after he had been pulled over and while Officer Hilton was sort of shining the light into his car. Again, I'll note each of those pieces of evidence was corroborated by another piece of evidence. Mm-hmm. And to get to your point, Your Honor, about it is feasible for somebody maybe to have been sitting on the seat in that car. Your Honor, I will acknowledge that it's not impossible. There might have been a way to do it. And if that was the only piece of evidence that the government had, maybe this is a tighter case. But that's not the situation we have here. We have testimony that is otherwise internally inconsistent with other evidence. He is outed as being a liar during the course of that testimony. And so his testimony is not credible. We have evidence from photographs and body cam making clear that it seems very unlikely, at the most, that anybody was sitting on that seat. And then you have the .22 caliber ammunition that matches the 20.
I think you've answered. Just before you go, just one question to make clear. It's somewhat of a counterfactual, but I want to make sure. Is it your position that a lot of these cases arise in normal state police enforcement, right? Local police.
Correct.
You're saying that they gather information, they have those things, and then that disappears. I'm not talking about this is counterfactual. It disappears, then you take up the prosecution, you meaning the federal government, then you're never responsible at all, have any liability, the fact that that's gone and that evidence is gone from spoliation point. Is that your position that, well, we never had it in our hands, so there's no jinx, there's no Rule 16, so are you saying that's your position, that your hands are clean in any circumstances in terms of that being not preserved, but then they give you over what they did keep, and you use that to prosecute, but the other part is gone. You say, I never had that. Is that your position?
Not quite, Your Honor. And I think the control in that case would be young blood and the bad faith argument. Mm-hmm. If local authorities have evidence and they destroy it in bad faith, then that would create a young blood problem and you could have different kinds of relief. If there is evidence that would fall under Brady, that is exculpatory and that is material, that would also be a violation of the due process clause, and there would be a possibility of relief there. But if the local authorities collect evidence, inadvertently lose something, and the government never has it, then there's not a Jenks problem. And if they're not part of the prosecution team for purposes of determining, for example, Giglio or some of the other information the government might be obligated to disclose, then there may not be any other discovery violation as well. I think, to be clear in my response to that question, that hypothetical, that counterfactual, I think would be governed by Youngblood and Trombetta and the Due Process Clause, and specifically issues of bad faith or Brady that gets eliminated or destroyed.
Thank you, counsel.
Thank you, Your Honor.
Mr. Jordan, you have some time preserved.
Thank you, Your Honor. I'd like to start, Judge Gregory, where you left off. I think the government's argument is surprising that they don't have any responsibility to preserve this information. This case was adopted federally while that information still existed. So Mr. Martinez-Chavez is arrested on New Year's Day. The case is indicted in March. So within the 180 days that these recordings still exist. The government is on notice that these recordings will be important because the government's own witnesses, Officer Poulin, other witnesses, state that they relied on hearing the dispatch recordings and writing their reports and in their actions. Officer Poulin testified that because he heard over dispatch that the car had blacked out, that's why he responded as he did. At JA 645, the government argued in the prior hearing that these officers were relying on the dispatch recordings in order to make their reports and in order to, as they testify. So the government knows that this is important and that this is out there. They can't immunize themselves by saying these are just state, these are state issues. By the time, while these recordings still exist, these officers become part of the prosecution team. They're government witnesses. The government has an obligation under Jenks to produce this information.
Counsel, I just want to make sure I understand what you think the relevance of the dispatch recordings would have been for the defendant's case. And I understood it the same way your colleague listed it out, that you thought the dispatch recordings might help to challenge officer credibility as to whether or not the defendant was speeding, whether or not he did the blackout, and then whether or not he reached toward the passenger seat. But I did not see anything in your brief saying they might have corroborated the existence of a passenger in the car.
They corroborate, I think, in the, or whatever the opposite of corroborate is. They indicate that the passenger could be there because I think the timing is important.
To show the timing, but,
and then
okay.
that's essentially why the dispatch is most important, is to hear the timing of when these things occurred. When did Officer Hilton say the car blacked out? When did he call into dispatch? With respect to how we can cross-reference this to the body cam. I mean, again, we don't have any body cam, we don't have any dash cam. All of the important things that happen are coming directly from Officer Hilton, and he's the only one who's observing them. And so the dispatch recordings are certainly relevant to that and to that issue.
I thought it was clear that there was a time when the officer lost a sight line to the car, and so it was possible, theoretically, that there had been someone in the car and he got out at that point.
Yes, and I think
Okay.
when I say that, I think this initially became clear to the government that these would be important at the preliminary hearing where there was more of a dispute about that. But that's when the government is saying, yes, the officers relied on these dispatch recordings. But it's clear that the timing is still important, even apart from the government agrees that there was enough time for him to get out, I think. That's what they're saying. But with respect to the timing of the blacking out, and was that really fleeing, or is that because he's just turning onto the street where his friend lives? And with respect to how much time is there between when he has Mr. Martinez-Chavez in handcuffs and the duration when all these things are supposed to have occurred. So that is the relevance of the dispatch recordings from the defense perspective, because this question of timing is a nice one that I think the jury isn't able to get at otherwise.
So the idea is, the timing is important because it might shed light on officer credibility as to these arguably evasive maneuvers that would in turn show consciousness of guilt.
Yes,
Okay.
yes.
I mean, because whatever we think the standard is here, there's going to need to be some showing of prejudice. And it does, I guess I just want to give you a chance to respond to my concern on this, which is that this all seems sort of like tertiary evidence at most. I mean, the government's main case is he's sitting in the car, he's the owner of the car, the driver of the car, when stopped, the only occupant of the car, and the gun is visible. And there's ammunition for both guns. And I guess their secondary case would be, and the one alibi witness who says otherwise is not credible. And then it's sort of icing on the cake, also like maybe he reached to the other seat. But it doesn't seem like it was exactly central to the government's case.
I see my time is up. May I respond? I'd like to correct the record on a couple of points, first of all. It's not Mr. Martinez Chavez's car. It's the family car. It's registered to his wife. He does
Okay,
drive
sorry.
it.
But it's not the alibi witness's car.
It's not the alibi witness's
Yeah.
car. It's not Mr. Vallejos's car either. It's neither of their cars. But Mr. Martinez, there's a stipulation that he does drive it. The ammunition is .22 ammunition, but there's never anything that links it to these particular guns, and it's in the console. The case, as to your sort of broader question, the government's case is only as strong as its weakest element. And so the issue of knowledge, certainly these things that you point out with respect to, is the gun in the car? Well, yes. But we also have Mr. Vallejos saying he just left it there. So that is something that the jury needs to consider. Whether we're looking at this as from the totality of the evidence, and I think we should consider as well, as we look at this, the ways in which the government's improper argument swayed the jury on these facts. But looking at the totality of the evidence, the jury just needs to get to reasonable doubt on this. And so is there reasonable doubt, given this, where a spoliation instruction would allow the defense to be able to say to the jury, you can assume that these recordings would have been beneficial to the defense. And one of the reasons that we have spoliation instructions is to prevent the spoliator from being able to benefit from their spoliation, right? And that's actually what the government was able to do in their closing, in their rebuttal closing. After the defense had made this argument about how there wasn't enough time, the government gets up and says, there's no evidence of that. There's no evidence of any time discrepancy. And the reason that there's no evidence of any time discrepancy is because the evidence that would have shown the time discrepancy was destroyed. And so that's exactly why we have spoliation instructions. Thank you, Your Honors.
Thank you, counsel. Thank you both, Ms. Charlton. You're not court-appointed in the traditional sense, but thank you for taking the assignment from your normal duties, and we appreciate that. Of course, Mr. Jones, you recognize your able representation of the United States. We'll come down, greet counsel, and proceed to the next case. Mr. Brewer?
May it please the court, I'm Charles Brewer from the Asheville, North Carolina Bar, and I'm here representing the defendant, Rebecca Lynn Barker. Your Honor, this case has been the subject of a great deal of briefing and everything. In fact, I'm holding here, it's pretty voluminous. But my argument to the court is that really this is a very simple case. When you boil it down to the necessary consideration this court has, it's the question of whether the search warrant, in this case, that was issued by the state of North Carolina to search the residence of the defendant complies with the Fourth Amendment of the United States Constitution. It's as simple as that. And then when I conclude the argument, I'll also talk about the simplicity of it as well in a case from Charlotte that I'd like the court to think about. On the big picture, the state issued a search warrant for the search of the defendant's property. And drugs were found at that property. And there was an affidavit, of course, that was attached to the search warrant. Joint Appendix page 87. The drugs were found at the residence, and state charges were brought. This was a state search warrant. State officers, state charges were all brought. All that occurred prior to the defendant, to the federal government issuing an indictment on the third day of August 2021, in which the defendant was charged primarily with a drug conspiracy. Now, the defendant filed her motion to suppress, alleging that the violations of the 14th Amendment, the Fourth Amendment of the United States Constitution on March the 4th, 2022. Thereafter, the magistrate judge, without any hearing, issued a memorandum and recommendation in which the magistrate recommended to the district court that the motion to suppress be denied. But importantly, in the memorandum and recommendation, the magistrate found that the affidavit in support of the search warrant did not provide probable cause to believe that the matters that would be found within the residence. Nonetheless, the magistrate judge recommended that the motion to suppress be denied on the ground of the good faith exception to the exclusionary rule. The memorandum recommendation found that the written objections to the M&R must be filed within 14 days. They must be in writing. It also stated in the M&R that any party that failed, the parties that failed to file those written objections would not be able to have the matter heard on appeal. That was all within the memorandum and recommendation. Now, time passed and no objections were filed by either party to the memorandum recommendation, and the district court entered an order adopting the memorandum and recommendation and denying the motion to suppress. That too was entered without a hearing. This is the big picture.
Just to make sure I'm following where we are, in that, what I take is the first adoption, not the reconsideration piece.
That's right.
Did the district court have some obligation to review that for clear error or mistake despite the lack of any objection?
I would think so, Your Honor. I would think so. But whether it reviewed it for that, there was nothing coming from the defense side. I mean, when the district court made its
No, but that's what happens when you don't object, right?
That's what happens
when you don't object to a magistrate's, or what I call an R&R. Apparently, you call it an M&R, whichever one it is.
Yeah.
The district court still has sort of an independent obligation to determine that it believes that it's correct.
I would think so. I would think that's part of the judicial process. The appeal now deals with whether the district court, under those circumstances, could grant could rule in favor of the defendant and rule that the motion to suppress should be allowed. And more importantly, that is a question of whether even this court can do so. And I think that, in fact, that it can, for the reasons set forth in my briefs, and which I'll refer to in a moment. So the issues before this court are whether the good faith exception to the exclusionary rule should apply, and whether the defendant received effective representation of counsel. And talking about the court's duty, there's also duties of the counsel. I want you to think of it from the defendant's perspective. There she is, in jail somewhere. She's hired at considerable expense counsel to represent her privately. She is rightfully, in my opinion, relying on that counsel to do whatever needs to be done to protect her interest. She doesn't know, she didn't receive a copy of the memorandum of recommendations, at least there's no indications she did. She didn't know whether an answer had been filed or could be filed or should be filed or must be filed. She's just relying on her counsel to do that. So her counsel's failure to do that, the court says, well, that's why there was no hearing, there was no consideration, because there was no answer. But from the defendant's standpoint, in jail, wherever it was, that's all irrelevant. To her, her case needs to be considered by the court, not on some technical basis, but on the reality of what the situation was. Now, it's important in this case to realize that the minimum recommendation and the judge's finding both found that the affidavit was insufficient. It was an insufficient affidavit. That was done without any argument from the counsel.
So then you need to get to the good faith part, because either way, right, counsel's only ineffective if that was a winner, and then that's the relief you need to get through with it. So
that's right. The good faith.
Get to that.
The good faith came all at the same time. At the same time the court found the affidavit was ineffective, the court found the good faith, excuse me, the good faith exception. At any rate, the finding in the memorandum of the recommendation that the holding of the district and the holding of the district court that the affidavit is insufficient can't be questioned any longer. It was a finding of the magistrate judge in the MR, and also a holding of the district court in the order denying the motion to suppress.
What do you mean it can't be questioned? I don't understand what you mean it can't be questioned any longer.
Yes,
it looks to me like the affidavit was sufficient for what it's worth.
No, yes, that part of it, the fact that the affidavit was insufficient is now judicially settled.
I don't why?
Well, because it was in the M&R.
Well, I know, but
okay,
assuming we can, assuming, as you appear to be doing, that we can reach the merits of all of this,
okay.
Are you saying that we could not affirm the denial of the suppression motion on the ground that, in our view, the affidavit was sufficient? I don't see why not. I'm not saying I necessarily think that, but I'm confused as to why that would not be open to us on review.
That was a judicial determination.
Well, I know, and hypothetically, we're reviewing that determination on appeal.
But, Your Honor, that determination was not appealed by the government.
Okay.
The fact that the government has not filed a counter cross appeal makes it judicially settled. Res judicata, that's the correct term.
That's why I said, seemingly you need to get to good faith, don't you?
Yes, so the question.
What would you have us? Can you just suggest to me what I look at to see that the government has to cross appeal in order to preserve an alternative argument like that? Like, what case should I look at? Because that seems the opposite of what I understand the cross appeal rule to require. When it requires relief that is different than what was afforded. You have to file a cross appeal, but here this is not a relief different than what was afforded, but is instead just an alternative argument for the very relief that was granted. And so what case should I look at to understand our cross appeal rules in the way you've suggested?
I'm not prepared to answer that. I do not know of any such case. I just do know.
So when you say they had to cross appeal to preserve that issue, that's just your sense.
That's my opinion, yes,
right.
Sir.
That's your opinion.
Yes, sir.
Great.
That's my opinion. So at any rate, in my opinion, the case that part of the case is judicially settled. The affidavit was inadequate. But aside from that, if you want to just look at the affidavit, it's very clear that the affidavit is inadequate. I mean, it's not a close case. You read it, and it's not
Mr.
one.
Brewer, can you get to that, assuming that the affidavit wasn't sufficient for establishing probable
Yes.
cause, as the district court, was the magistrate found,
Yes.
and then that good faith instead exception applies, can you get to your argument that good faith doesn't apply? Because you don't have much time, you use about 75%
Oh, I'm sorry.
of the time.
Well, definitely, there's not a good faith exception in our opinion for the reasons set forth in the briefs, you know.
Oh, so you're going to rest on your briefs on that?
No,
Okay,
no.
well, let me know then, because that's, your time
Okay.
is up to talk to us. Go ahead,
I believe-
argue your case the way you want, sir.
I believe that if this court had, and I'm sure it has, read the affidavit, and if it thought that the ruling of the judge denying the motion to suppress was accurate or rightful on the merits of the case, never any request for supplemental briefing, and the case would not be here for arguments today. That's my opinion
No,
of
it didn't
the
work that
court's
way,
posture.
Mr. Brewer. The
Sorry?
court said that, never mind, go ahead.
At any rate, between the time the district court entered its order denying the motion to suppress and the filing of a plea agreement, the defense counsel filed 5 or 6 documents, I don't know the exact number, all set out in the brief. And in those, you know, all were inadequate for some reason or another. But nonetheless, they did attempt to show the reason that the defendant failed to file timely objections to the pre-sentence report.
Counsel, can I ask you a question about your client and your client's preferences? So we are the ones, this court raised this issue about whether your client's plea, conditional plea was valid.
Yes.
Because maybe there was not a meeting of the minds as to exactly what right to appeal had been preserved. Is it your understanding, does your client want to have this plea agreement set aside?
Well, if there's no other relief available, I think she does. But she really thinks.
You think she does? I mean,
Yes,
we
I'm
think
not-
the cross appeal rule is something, but like, do we know that that's what your client wants? I mean, it'd be I'm not saying that this is an argument that I think wins, but it'd be a bad day if we raised an issue that she did not raise through her counsel, and then we granted relief on that issue, and she got what she did not want.
Yeah.
Right? I mean, and it may be she wants it, maybe she doesn't, but I would just say, I'm not like terribly comforted by I think that she would like that.
Well, I know what she does want. She does want the court to look at this search warrant and determine whether it should be granted or not. That's
Totally
what
understand
she
that.
really wants.
But what
And she doesn't want the technical problems with what her lawyer did or didn't do stand in the way of her getting what is essential justice in this case.
Okay, but say, I guess, I mean, I really do have a concern, just sort of institutionally. We sometimes flag issues that defendants have not raised, and just assuming hypothetically on this complicated decision tree, we are at a point where we are trying to figure out if this plea was valid or not. Do you have any more definite sense of whether your client would want to have this plea invalidated if that were the only relief available?
Well, she of course wants the plea validated, but the thing she wants about the plea most important is the plea specifically says that this court's going to look at the plea, at the search warrant. That's what she wants. She wants this court to look at that search warrant and determine whether it's facially valid and determine whether it should be, because the rule should be allowed even though it is insufficient.
Mr. Brewer.
Yes, sir.
Even if we look, and we will look at everything for us, what you say, we promise you that we do that. But what I'm saying is that even looking at whether or not it is a valid warrant and should have properly been issued,
Yes, sir.
if we found that it was not,
Yes.
then we have to decide, does the exclusionary rules that exception of good faith apply, right? You understand that, right?
Yes, sir,
But
absolutely.
why aren't you arguing as to that? That's why I said a long time ago, your time is up now, and you haven't said a word about whether, if this was an invalid warrant issued, that the good faith exception wouldn't apply, or does not apply. You haven't argued that at all.
I do have arguments on that, Your Honor.
You do have arguments?
Yes,
on it?
sir.
But you do not have time.
Okay, I'm sorry. Well,
But on the sake of your, no, wait a minute, for the sake
but
of
the
your,
arguments
no,
are-
wait a minute, wait a minute. I think you ought to let me talk right now.
Yes, sir.
'Cause it may help you.
Yes, sir.
For the sake of your client, I'm going to give you 5 minutes to do so. And I'm the lead judge, I can do that. But for the sake of your client, I want you to argue why the good faith exception does not apply, if you're assuming, and I know you don't have to assume that that it is invalid, but if it were, that the good faith exception does not apply. Can you argue that?
Okay. The arguments actually come from the brief, but the main thing I'm looking at, the main thing that I think the court
You said-
should
You still want
consider.
to rest on your briefs on that?
No,
Okay,
The
well,
main
stop.
thing,
Just please, stop. Go
the
ahead.
the main thing the court should consider, in my opinion, is the Wilhelm case. Wilhelm was cited both before the trial court and also multiple times before this court. It was decided in 1996, and it heavily is leaned upon by the defendant in this case. It says that where good faith exception does not apply, there are 4 situations which it does not apply. 4 situations. 3 of them are applicable to this.
Okay.
First, the magistrate has simply acted as a rubber stamp for the police. Second, the affidavit does not provide the
Can I
magistrate
just
with
stop you on one? How can you say the magistrate acted as a rubber stamp for the police when the magistrate found that there was not probable cause in this case?
because there was nothing in the affidavit to suggest it.
Okay.
But that is one of the exceptions. The other is the affidavit does not provide the magistrate with a substantial basis for determining the existence of probable cause. That's clearly true. That's clearly true. Found by the magistrate, also found by the district court judge in his order. And the third situation where it does not apply is when the warrant is so facially
I'm sorry,
deficient.
so your argument is that the federal magistrate and federal district court judge found that there was no substantial basis in the affidavit for probable cause?
I think so. They said because he specifically said.
Because you think this is the same thing to say there's no probable cause as to say there's no substantial basis for probable cause?
I think so. I could be wrong. I think so. So at any rate, the Wilhelm also talks about bare bones affidavits. And Wilhelm says that the state magistrate could not have acted as other than a rubber stamp in approving such an affidavit. So when the court's saying that they did act as a rubber stamp, therefore there's a denial, direct connection between the strength of an affidavit and the good faith exception.
There's 3 or 4 page attachment for the affidavit, wasn't it? I mean, but just to call that bare bones is kind of hard, isn't it?
Well, I think when you look at it and see what it actually says, I think that's
It
what.
may be, but to say that's bare bones.
Yeah,
it's
but
kinda-
that's what I'm saying
All
it
right.
is.
Go ahead, okay.
Okay, also this concern for bare bones affidavits is brought out in the Leon decision in the Supreme Court in 1985, which states the magistrate must be a neutral and detached individual and not just an, quote, adjunct to law enforcement officer, which is what I say this is. The court needs to consider now the holdings of this court in Wright versus Collins, which recognize that the failure to object waiver rule is not absolute. That's a quote from the decision, is not absolute. Also, this court in 2020 noted that the fact a party has waived review does not end the matter. The Supreme Court in Thomas versus Arnn held that the waiver rule resulting the failure to testify is subject to is a non-judicial rule. It's non-judicial. So the Supreme Court says it's non-judicial, and therefore gives to you, as the Court of Appeals in the United States, the authority to excuse the default. So that's what I'm saying. We're here under Arnn saying, yes, there's been a default, and the Supreme Court has said that since it's non-jurisdictional, you can excuse it, and we're asking you to do so. In Bundy, it sets out requirements for a conditional plea, and it sets out 4 requirements. I don't guess I need to read them, but in each of the 4 requirements, he complies. This is an appropriate conditional plea, and therefore the court should take it under consideration. And the last case in your order was Hill, and that simply says that the defendant must show some specificity, and he has in all those filings with the district court shown the necessary specificity. The second issue in this case, Your Honor, relates to ineffective assistance of counsel and whether it's conclusively shown on the record, and that cannot be waived. That has to be considered and reviewed and considered. And we say that it has been conclusively shown that she has received ineffective assistance of counsel, and therefore the Sixth Amendment provides relief to her. And then finally, we say that the position of the government in regard to the supplemental pleading saying that this court should not even consider the defendant's appeal is inconsistent with the plea agreement, which is before the district court, and we consider that improper. Your Honor, I said I'd end with the simplicity. It's a quote that I love a lot. It's from Judge McMillan in Charlotte, in the Poe versus Charlotte Hospital. He says, due process in simple terms means fair procedure. And we say that the only fair procedure that can take place in this case is if this court accepts the appeal and rules upon whether or not the good faith exception is proper or not. Thank you, Your Honor.
You want us to rule on whether or not it was good faith, right? That's the last thing you just said?
Well,
No,
yeah.
no, wait a minute. This is not an argument. This is just a direct question. I just want to punctuate something. You just said we're supposed to rule on good faith. Didn't you say that?
Maybe I did. I'm not sure, Your Honor. But
And you didn't argue a bit of it.
at any rate,
Go ahead.
At any
Your
rate,
time is-
the court needs to just look at this in its totality and determine whether or not the good faith exception applies. And we say it does not.
Okay. Thank you, Mr. Brewer.
Thank you, Your Honor.
Ms. Ray.
May it please the court, Amy Ray for the United States. Your Honors, this court should affirm the district court. The search warrant provided probable cause to support the, search warrant affidavit provided probable cause to support the issuance of the search warrant. The good faith exception does apply. I guess I want to turn, I'm a little bit, I'm not sure about what concerns the court has this morning. In terms of the supplemental briefing, I'll go ahead and begin with that because I'm going to assume that given that order, this court wants to consider whether or not the conditional plea is valid and whether or not the defendant waived her right to, yes, Judge
Can I
Harris.
ask you a question? Right, and fair enough to be not entirely clear where we are on this, and this is one of these cases where we, as a court, have perhaps complicated the case.
Oh.
And so can you, what I would appreciate, if you can give me any guidance, if you assume hypothetically, just hypothetically, I think it's pretty clear the good faith exception applies at a minimum. And given the procedural issues we have raised, what would be the most straightforward way for us to resolve this case?
I think the most straightforward way would, I mean, there's a couple of, let me think about that. I think that in terms of whether the defendant waived, I think the answer is yes, by not objecting.
But that's not jurisdictional, right? Couldn't we
It
just
is
skip past
not
that?
jurisdictional, so this court could decide, which frankly is, I had to make the decision too, whether to assert that waiver, and I decided not to.
Right, and in light of that, I mean, it would, we
And-
often say if the government has waived waiver,
Could
it's
also
not
say the
jurisdictional,
government
let's
waived
let's
waiver
go.
and
Right.
go straight to good faith exception. And say that that's the way, you know, that the district court's decision should be affirmed based on the good faith exception.
And then the plea issue would fall out of the case.
The plea issue would, but I also do think, and I will just explain why I think the plea is valid even if the defendant waived and the court wants to excuse that waiver and think about the implications for the conditional plea agreement. And I will confess that I don't think my supplemental brief was especially helpful. I mean, I think I made the arguments that, yes, it's still valid. But as I reviewed this case for oral argument, I found that, more specifically, this court has 3 decisions that I think give 3 different standards for how a waiver under Rule 59 should be considered on appeal. So in the Arrakis case, this court compares the waiver under Rule 59 to the failure of a party to raise an issue in an opening brief. If it's like that, then what this court would do is simply decide, you know, we're going to excuse that waiver and we're going to consider that question on the merits. In Cabrera-Rivas, and that was a decision that was just issued last year, this court said, well, under Rule 59, the defendant has waived it, we're going to consider that a forfeiture, and we're going to address it under the plain error standard of review. That's different from Arrakis, right? And then in Diamond Life and in Hill, this court simply said it's waived, therefore there is no appellate review. So in all honesty, as I look at this, I see 3 different standards that this court has applied. I don't know which one the court believes is accurate. I don't know that there's really a case in which this court has wrestled and grappled with that question in any way other than kind of here it is. What I will say is that even in Thomas versus Arnn, the court says it is not jurisdictional, and therefore the Court of Appeals, it's up to the Court of Appeals' discretion. And that is the reason that I think it doesn't invalidate a conditional plea agreement. I don't think it's Bundy, because in Bundy, the issue was, is this plea agreement valid because it wasn't in writing or it wasn't clear? And so therefore, if it's not valid because it doesn't satisfy the Rule 11 requirements, then it has to be unwound. And this isn't that situation. It's this plea agreement satisfies the Rule 11 requirements. And because this court has the discretion to review the question of the Rule 59 waiver, has the discretion to go ahead and consider the issue on the merits, I don't think it requires the invalidation of the conditional guilty plea.
This is really helpful. Does that mean that the Diamond Life Hill line, like, just can't be right? I mean, we often use the word waiver,
Yeah.
and as a misnomer. We use lots of words as like wrong. But waiver's like an intentional relinquishment, right? And
Right.
as I look at those are cases that are like, they're actually forfeiture cases. They're not true waiver cases in the technical sense of the term.
Mm-hmm.
And do you think that that's sort of the right way to think about those cases? Is that they weren't announcing sort of a categorical bar, that they were saying there was no review in that case, but leaving open, as we've said in later cases, and we might debate exactly what the standard is, that a failure to object to an R&R or an M&R,
Yeah.
as it might be in North Carolina, is not a categorical bar on this court's review. It might affect the standard by which we review it, the same way it affects the standard by which the district court reviews it?
Yes. And I think that Thomas versus Arnn, given that that's a Supreme Court case and says that there's Court of Appeals discretion, suggests that in the Hill and Diamond Life case, can't reach the decision that it's absolutely unreviewable. And I think that, you know, again, as I sort of looked at these cases
Would
more...
be an odd thing anyway, because we acknowledge that the failure to object not only allows, but requires the district court to perform effectively clear error review.
That's right. There's
And
still
so they
a
have
review.
made a clear error determination, and it would be an odd world for us to say, the district court has performed a review, and we are categorically barred from looking at whether the district court got that decision wrong.
Right. I will say, I mean, and this court knows this better than I do, but I mean,
Maybe not, we've given 3 different lines.
Well, in a perfect universe, there would be a really clear distinction between forfeiture and waiver, right? And the court would never use the term waiver when what it really means is forfeiture. And this case is a perfect example of these cases that I've cited that have applied 3 different rules, is because Rule 59 calls it a waiver, but it can't really be a waiver in the traditional sense of it's absolutely waived. Maybe there should be a third category. It's waived, but we can excuse it. Well, if you can excuse it, does that mean you decided on the merits, or do you apply plain error review? And I don't.
Also, another
Yeah.
just weirdness that I have struggled with in this case and the way we have presented it, again, just assuming hypothetically, I think it's the good faith exception applies here at a minimum. It's weird to talk about excusing a waiver in order to rule against the defaulting party. Like usually when we talk about excusing a waiver, it's to
Yeah.
rule for the party that defaulted.
Yeah.
This is just conceptually a very odd grafting of some waiver cases where we are cases where we excuse a waiver like Arrakis in order to find for the defaulting party. And I think there's sort of an assumption built into those cases that one of the factors is the defaulting party has a pretty good case on the merits, so there would be a reason to exercise our discretion to reach it. And again, I'm building in an assumption here that the good faith exception applies. But if I thought that, it seems like those cases would not speak directly to a situation like this.
I mean, the odd thing in this case is you sort of have 2 waivers, right? I mean, not only did the defendant waive by failing to object, but we've waived by not asserting that waiver.
Because the merits are more straightforward.
It was actually a purposeful decision that I made as I reviewed the circumstances in this case and made the decision that this court, in my experience, the application of whether this court applies a waiver or not, I don't count on the fact that it would. And under these circumstances, I just decided not to assert it because, in my opinion, the merits were pretty clear. And because the district court had actually considered the decision, the question that the defendant had waived, and I just decided that, so you have 2 waivers, it makes it a little more complicated. I will say that for what it's worth, and I understand this is kind of outside my role as advocate in this particular case, it would be lovely if this court clarified what rule applies. I know in Cabrera-Rivas, I was surprised that the court applied plain error review in that case. I will also say we did not brief what standard of review would apply if the court excused that waiver. So I don't think in any of those cases that have the parties briefed at length or really briefed at all what standard of review should apply in a Rule 59 waiver context. So if this court wanted to clarify that in this case, great. I don't think it needs to. I think this court can simply say the government waived it, or this court doesn't even necessarily have to address it at all by just moving to the merits.
This is very helpful. How would we do that, given that Cabrera-Rivas sort of seems to resolve it? I mean, that's a panel decision that resolved it. We would sort of maybe have to say that Arcus, which seems like a quite different setting, right, involving an agency, that somehow controls over Cabrera-Rivas? Like, how would we do that as a panel? I understand your idea, maybe an en banc court ought to fix all this.
Yeah.
But aren't we sort of bound by that Cabrera-Rivas decision? Given that we sort of take Diamond Life and Hill to not mean exactly what maybe they suggested in light of Arn and otherwise.
Right.
But then Cabrera-Rivas, I can't say that about Cabrera-Rivas, right?
Sure, right.
I mean, so
No,
it seems like
yeah.
to me that's
That's
that is the
consistent.
standard now. It might have been unclear at the time, but if I was, trying to figure out the current state of the law, why wouldn't
Yeah.
I take that as the binding panel decision on this question?
I guess only because of the existence of a raucous. I think if this court wants to say, well, that was a civil context and that was not, and there is no plain error in the civil context that I'm aware of, and so this court could certainly say Cabrera-Rivas controls, great, then apply a plain error standard of review if this court decides to excuse the government's waiver, which I'm happy for it to do, and I argued in response to the supplemental briefing order that the defendant certainly did waive under Rule 59. Then under the plain error standard of review, the defendant would have to show not only that there was probable cause or that it would have to be plain error, that the good faith, I suppose the good faith determination would have to be plainly erroneous, and the government would still be arguing as an alternative basis that there existed probable cause to support
And we
the
would
affidavit.
review that effectively de novo because it's
That
an
would be de
alternative
novo.
ground for affirmance.
Yeah,
But
sorry.
But just to be clear, this is, in your view, this would not be a case in which the standard of review matters. Under any standard of review, de novo, plain error, you would say the good faith exception clearly applies.
That's right, which is why I didn't assert the waiver to begin with.
Right.
But yes, so I suppose turning to the merits briefly, I believe that the affidavit does provide probable cause. The affidavit was actually very specific, and this court's opinion in Grossman says it's reasonable to suspect that drug dealers store drugs in their homes. They knew that Ms. Barker had had recent drug charges against her. She goes out at 6:30 a.m. They find her in possession of a controlled substance and a firearm. They then see Gil, who they know very well, is a drug dealer, leave her home, and she takes off quite a high-speed chase and fight. And then they find her.
They know that leaving her. When he said I saw her leave, what does that mean? Leaving her home he obviously didn't see her on the property because I'm sure he would have said that.
No, he says
He said leaving. But what does that mean?
he was surveilling.
No, I know that part. What does it mean by leaving? Did he see her on the property?
Yeah.
No, but it didn't say that.
Your Honor, I believe that it said he would return to surveil Ms. Barker's home. So he's watching her home, and he sees Gil drive off. I can get to the.
I know, yeah, but
Yeah.
that's my point. Yeah, he said, but that's what he said, leaving. That's what he said. I think he said leaving her home,
In a Jeep Wrangler, a rented Jeep Wrangler.
which means he didn't see her when she came out of her home or went in, right?
Right, but leaving specifically the home, meaning at least the driveway.
Well,
So
he didn't say that either.
he did not say the driveway, but he said she was leaving Barker's home, like that. He was watching her home, and then he sees Gil depart from there.
Well, you may make that conclusion, but he didn't. Seem to me, if you trying to get an affidavit, you would say, I saw her come out of the home.
Yeah.
Right, but he didn't.
I
so-
don't think that he saw her leave the home. Let me say this, Judge Gregory. At a minimum, it's a reasonable inference from the affidavit that he saw her leave the driveway. That's a reasonable inference because he says, I came back to surveil the home. I came back and it was 2:00 in the afternoon, and I saw Gil in a I think that point, it was a white Jeep Wrangler. She had just been in yes, it was a white Jeep Wrangler. And I saw her leaving. So the inference can
Where
certainly.
did you get the driveway from? What's the inference of the driveway?
I don't know. What I'm saying, though, is when he says, I'm watching her home and I see Gil leave, that there's a fair inference that a magistrate judge could draw that Gil had been at her home, and that's why she was leaving the space of her home, whether there was a driveway or was in front of the street. I don't know, but he was watching her home.
This is the white Jeep Wrangler?
I believe so.
So he says, this is the
Thank you, because I
detective
didn't pull it up.
describing it. A white 2020 Jeep Wrangler left the residence.
Okay.
It was operated by Jane Gill. And so,
Yes.
I mean, it seems like the objection that the magistrate made there was, well, we don't know whether Jane Gill came out of the residence. That seems to read it awfully thin, right? I mean, there's a state magistrate who's reading this. We give some deference to the magistrate doing it. You might be able to read that there is a gap there when it says the white Jeep Wrangler left the residence operated by Jane Gill. It doesn't exactly connect the dot that Jane Gill came out of the residence, but Jane Gill was plainly at the residence and leaving.
Right. Yeah, I think the question is really, is there a fair inference?
Right.
Can the inference be made? And I believe that the inference could have been made, and could be, and should have been. I would have made that inference. So they also knew that Gill was very active in the drug trade. She tossed out 60 grams of meth during this chase, and then they found more than $100 of cash in her car. I think that those facts under this court's decisions in Grossman and other cases that generally recognize that when we see enough facts, it's a fair probability. It's not a certainty, it's a fair probability. I think that's enough. Now, turning to good faith, I would note that this court's 2019 decision in Searden says the threshold for denying good faith where there is a warrant is a high one. Officers are not expected to question conclusions of issuing authority where there's a warrant. So it has to be really, it has to provide so little probable cause that no reasonable officer could rely on that warrant. This is not that affidavit. This affidavit is several pages long, very detailed. Even if this court were to hold that there wasn't enough to provide the nexus for probable cause, that would be a decision that is at least not one that's very clear under this court's precedent. And I think that in that situation, it doesn't nearly meet the threshold required under Searden to say that there's no good faith. If your honors don't have further questions, the United States requests that this court affirm the judgment of the district court, and thank you very much.
Thank you, Ms. Wright. Mr. Brewer, you have some time reserved.
What she just said is, if there's a warrant, there's always good faith. I just think, I don't see why there is such a thing called the good faith exception to the exclusionary rule. If every time there's a warrant, there's good faith. We think that when you distill the affidavit, it is very thin. It is very thin, and I don't think the good faith exception should apply. I think this court should take the case. I think the court should review it and determine whether there was. I don't think you should have to determine whether there's sufficient evidence in the affidavit, because I think that's already been judicially determined, at least to my satisfaction. But if you do, I think you should determine that there is not sufficient probable cause in the affidavit, and I think you should determine that there was simply no good faith exception that should be applied in this case. Therefore, rule that this search was improper, the fruits of it were improper, and should not have been admitted in the case.
All right.
Thank you.
All right, Mr. Brewer, we acknowledge that you're a court opponent, and On behalf of the Fourth Circuit, we appreciate lawyers who take these cases, and we thank you very much. And Ms. Ray, as usual, you're very able representation of the United States. We'll come down, Greek Council, and proceed to our last case for the term. Mr. Fon?
May it please the court, and good morning. It is an honor to be here. I haven't been here for 25 years. It's an honor to be here. I'm Tim LaFawn, and I represent the appellant Larry Clay. This case comes on as an appeal of a jury verdict against appellant Clay in the Southern District of West Virginia. He was convicted of conspiracy to commit sex trafficking, and 2 counts of obstruction. The facts are that Clay was accused of conspiracy with his co-defendant of coercing a 17-year-old to have sex with him in exchange for payment to the co-defendant, being the victim being the co-defendant's daughter. According to the allegations, this happened on 2 different occasions, and all was done while Clay was a police officer and in a police uniform. Given my limited time, I have 5 errors that I'm bringing to you. Given my limited time, to the extent I don't get to the last 2, I'll submit on the brief.
Sorry, before you move on,
Excuse me?
Sorry, before you move on from your last error, the sentencing error, I did want to confirm that you want to continue pressing this argument, since the government points out in its brief that even if you are correct about these 2 sentencing enhancements, the offense level doesn't change, the guidelines range doesn't change. Is this an argument you want to continue to press?
I will simply submit it on the brief, so I'm not going to speak to it today.
Well, I
I
guess I am asking why. Why would we rule on that when it would not change the offense level or the guideline?
I agree it would not. Your Honor, I was just trying to point out the errors, and so okay. I agree it would not change the sentencing guideline. Primarily, the issue I wish to raise with the court is a term. I guess it's a term that maybe is improper, but it's used often in the case law, an unwaivable conflict. To this issue, it is undisputed that a criminal defendant has a Sixth Amendment right to effective counsel, and that was established in Wheat versus United States and Gideon versus Wainwright. What I'm here for today, Your Honors, is probably best highlighted by the case, the Fourth Circuit case Stanko versus Sterling, in which this court acknowledged a defendant's right to effective counsel and a conflict-free counsel, and highlighted that there are situations that district courts should not allow a waiver of a conflict if the trial would not be conducted within ethical standards of the profession, and that legal proceedings appear fair to all who observe them, and that interest can justify, in rare circumstances, insisting on conflict-free counsel even when a defendant would prefer to proceed with conflicted counsel. In that particular case, the Fourth Circuit stated that it had not had the opportunity to highlight specifically what that means, but I believe in this particular case, Your Honors, this case has to meet that standard. What happened in this case is right before the trial, the U.S. attorney.
Can you just address, you just suggested there that, there's a lack of clarity is exactly what constitutes an unwaivable conflict. It seems maybe fair. Can you square that with the fact that we're reviewing this for plain error? Because there was not an objection below, even assuming we got past the Rule 33b2 problem. And if there's a lack of clarity, it means whatever error, if one existed, was not plain. And so help me understand how I'm even getting to this argument where you're sort of trying to add substance to what constitutes an unwaivable conflict. Don't we have to find like an express idea that then was plain to find that the district court erred here?
Well, I think the expressed idea is the fact that if this case doesn't rise to this level, none does.
Well, can I ask you about that? Because honestly, I take it the premise would be that the counsel, right, we know the facts, that the counsel will be deterred from impeaching Ms. Naylor-Legg with her recanting letter because that would bring out these accusations that he had engaged in witness tampering. Okay, so after the conflict hearing before the district court, I am just having trouble as a common sense matter trying to figure out why the lawyer would be very worried about that, given that the only person saying he engaged in the witness tampering, if I'm getting this right, is Mr. Naylor-Legg's husband, who gets on the stand and, well, we talked about this in our first argument today, but certainly seems to be lying his head off, and the district court says he is completely non-credible. So I am struggling to figure out what Mr. Joy would be worried about at this point. There's no serious case that he engaged in witness tampering.
All I would say, Your Honor, is he was warned in the motion hearing applicable to the notice of conflict. He was warned that if he introduced a very pertinent letter that had been written by the co-defendant recanting her, if he introduced that, right, how it was obtained would be raised in the trial.
Yeah, right.
And that would have only hurt him, and not putting that letter into the trial of this matter.
I'm sorry, how would it have hurt him? Because Ms. Naylor-Legg's husband would have come in to give his incredible testimony?
Well, I believe what would happen is the co-defendant would have stated that it was brought on improperly, and that's the reason why she recanted it. Because that would have been the only person who could have said that. And in fact, the matter is that the letter says she.
Why do we think that that's what the co-defendant would have said?
Because the letter.
What's the basis for us concluding? Because we don't have a record that that's what would have been said, right?
We do not. But the point being is that the letter recanted her entire plea agreement. She was testifying under that very plea agreement. She's the only one who could have explained, well, why did I sign that letter recanting it? And then at the same time, I'm going forward with my plea agreement here. And it's got to be the only way that evidence could have come in, and is that's how that recant letter was obtained.
So we would have to conclude that the only way that a criminal defendant changes their story is because of witness tampering?
Oh, I'm sure that's not the only reason, but
right.
that's the reason. That's the reason it happened.
What I'm getting at, right, is that seems like to me there are a lot more plausible explanations for why a witness might change their story and return to the original story in the context of a criminal prosecution that doesn't involve witness tampering. Well,
but it's my understanding of the record, because I didn't try this case, but it's my understanding in the record that at the hearing about this potential conflict, she testified that that's what happened. I mean, and that's the reason that the story was recanted, that she was relying on what her husband had told her that would happen if she recanted her story. And it's either that or her husband is going to testify to that. And this lawyer had been threatened that if you bring it up, we're going to bring into how this was obtained. It made no sense not to cross-examine that witness with that letter. Zero. The recantation letter, she backed off everything she said in her testimony. And yet it wasn't admitted, and it was the only sensible conclusion is it would have affected him and not this trial. And it would not have affected it would have helped the defendant.
Can I ask you just a question about the structure of your argument here? Just assuming hypothetically we agreed that this was an unwaivable conflict, so there's no valid waiver, I think what would follow from that, but tell me if I'm wrong, is that that would put you back at Kyler and Mickens, and you would still have to show the adverse effect on counsel's performance under the Mickens factors, and I don't see you making that argument in your brief. So even if you are right that there's a conflict here, that only sort of gets you in the door, and you haven't argued kind of the rest of your case. So why wouldn't we affirm anyway?
So the adverse effect, I believe, and I presented in my argument, is the letter was so strong, the only sense that it made not to cross-examine with that letter was to save the lawyer from the adverse effect of the implication that he committed a crime himself.
But your brief says that something like, we will never know why counsel didn't impeach with the letter, but you actually have to show to prevail the reason why counsel didn't impeach. Again, I'm not trying to prejudge or intimate anything about how this inquiry would come out. I'm just pointing out that you haven't argued it in your brief. So I'm just having difficulty, even if I agreed with you that this was an unwaivable conflict. Tell me why that is enough for a reversal in this case.
Well, as the court's aware, it's impossible to know what would happen had it been presented.
You have to prove what would happen in order to prevail, so I don't know why you keep saying that.
How could you ever prove that a jury would have decided differently had they had that letter?
Oh, not that part, sorry.
I mean, I don't know how you could ever prove that until you retried the case. The point being is there's no rational basis not to have cross-examined that witness with that letter. If you read that letter, it's strong. She talks about being coerced by the U.S. Attorney's Office.
Is that the standard that you're basing it on, that there's no rational basis? So that, I mean, is that, maybe that's the sort of like rub here, that you're just saying that like there is no rational basis for not using the letter, right? Because it strikes me that the letter could have been like worse rather than better. I can totally imagine why a defense lawyer would not use it. And so I guess if that's true, if I can envision why a defense lawyer who had no conflict whatsoever would choose not to bring that letter in, is that sufficient to resolve your case?
Well, I don't think it is.
No, I understand, but I just accept that as a hypothetical, that there is a rational basis for why a good defense lawyer would not open that can of worms. If that was true, would that, per Judge Harris's question, sort of resolve the matter?
Well, the point I'm trying to make is I don't think it resolves the matter because my client had a right under clear error doctrine. My client had a right to have a fair and effective counsel, and shouldn't have, the decision to be made by this counsel that was representing my client should not have been tainted by these threats against him.
And so it's, in your view, it's just a per se reversible error. If there's an unwaivable conflict, it must be reversed, in your view.
I think based upon clear error, that's clear, and it's clearly error, but not use that letter or even put a client in that decision. The person who coached and talked to the client about this before the client waived is this very lawyer who was subject to this threat. And that's where he got his advice on whether he should waive this or not. That's a conflict that you...
Am I misremembering what happened? I thought that after Mr. Joy does not cross-examine with the letter, the district court once again wants to get another waiver, and I thought this time Mr. Clay did consult with a different lawyer. Is that not right? One of the lawyers he consulted with was this very lawyer. There was a lawyer that, and I'm not sure this is in the record, I want to be candid, but I know this is a fact. He had a lawyer that was a civil lawyer, happened to be in the courtroom observing because he was involved in a civil case. That's the other lawyer you got to talk to in a brief few minutes outside of the presence. Yeah,
and he had to make a waiver based upon the advice of this lawyer who was subject to this claim. And that's simply not fair counsel. And with all due respect to Justice Richardson, I try cases mostly. I do not come to the Fourth Circuit very often. I've been here for 25 years. I can't think of a reason not to have cross-examined with that letter.
Well, wouldn't it be that it doesn't really reflect that well on the defendant? Because it just kind of looks bad, like maybe Mr. Clay is pressuring witnesses through his lawyer.
Well, there's no evidence of that.
Well,
I guess the inference could be made, but there's no evidence that he had anything to do with that alleged witness tampering.
Yeah, does the letter say, implicate him doing anything wrong?
No.
Right.
It simply backs off the confession given by the co-defendant and the method by which that confession was obtained. I want to move quickly past this issue. I know that there's some procedural arguments. I think that this is a situation, the very person who filed the motion for new trials was this very same lawyer, and he didn't raise this issue. Couldn't have expected him to raise those issues.
I thought there was something like 10 months after the new lawyer started before the motion was filed. Is that not right?
I'm the new lawyer.
Oh, you're the new lawyer. I'm sorry. Why did it take 10 months to file the motion?
Well, and as I said in my brief, of course, it got denied based upon just being past the 14 days. As I said in my brief, I got appointed, and then I had a kidney transplant. And so that postponed the case, and then I'm the one that raised the issue of ineffectiveness of counsel based upon an unwaivable conflict. So that was the gap of time in the 10 months or so. I would like to move on to...
Did you raise, just out of curiosity, I think you're out of time, you can answer this on reply, but did you raise the kidney transplant argument below? So in other words, did you argue to the district court that there should be excusable neglect in light of your own health situation?
Well, I did not, but they were certainly aware that I had a kidney transplant because they granted the continuances. Thank you. I will submit the rest on the brief, Your Honor.
Thank you, Mr. LeBron. Ms. Harrell.
May it please the court, Jennifer Harold on behalf of the United States. This court should affirm Mr. Clay's conviction and sentence in this case. With regard to the issue that was just discussed about the unwaivable conflict, the court correctly denied that as an untimely Rule 33 motion. While Rule 45 does permit excusable error in certain circumstances, that was never raised in the motion to reopen. It was not raised in the reply to the United States response, and it is not an abuse of discretion by the court to fail to make a Rule 45 argument on behalf of the defendant. This is a rigid claims processing rule. The United States invoked it, and the district court did not have discretion to avoid applying that rule. In terms of the conviction itself,
But before you leave that, can you walk us through why you think that this is not a situation where that a lawyer ought not to be burdened with even just the specter of something like this? Just tell me
whether the original,
facts. Yeah.
well, in this case, the United States raised this conflict issue as under its obligation to raise anything that could potentially be a conflict so that the court could address it. The United States was basing this on jail calls between Ms. Naylor-Legg and her husband.
Mm-hmm.
At a hearing that was held,
That they have been recorded.
they've been recorded, yes.
Right,
They were
okay.
supplied to the court.
Mm-hmm.
There was a hearing held, and during that hearing, the husband said, I made all that up. Mr. Joy never said anything to me about this. I was providing my wife with misinformation because I did not want her to plead guilty. And he described it as Mr. Joy being his source of hope because he somehow thought that Mr. Joy could get his wife out of prison. She testified that she wrote the letter asking for new counsel and recanting her stipulation of facts in her plea agreement because she believed her husband. So the testimony and the evidence and record was that Mr. Joy never said anything to anyone to try to influence her decision to get new counsel, her decision to recant. It was all Charles Legg, and the transcript does not do that hearing justice. The court was correct that his testimony was, nothing he said made sense, and it was easy to understand why he might have been telling his wife a lot of misinformation to try to convince her to do what he wanted her to do. So the court did not actually have before it any evidence that Sebastian Joy had actually engaged in any improper conduct whatsoever. The court, out of an abundance of caution, after taking a very long recess to consider it, decided to find that there was a potential conflict because it might create an appearance in front of the jury.
Appearance of what?
An appearance that either Mr. Joy or Mr. Clay might have a conflict with regard to a witness tampering accusation. Because it would come out, if they used the letter, the United States advised the court and defense counsel that we would inquire as to why she wrote that letter, and she would explain that she believed that Mr. Joy would help her. She would also testify that Mr. Joy never said that to her directly, and she only heard that from her husband. So the inference would be she was under potentially a misimpression that did cause her to do this. But in terms of why Mr. Joy wouldn't put on that letter, the defense argues that he would have been afraid that if it came out in front of the jury, he could face sanctions, he could face various personal and professional repercussions. If he was going to face personal or professional repercussions, the fact that we had an entire hearing about it would have kicked that off. So whether it came out in front of a jury or not would not have had any personal effect upon Mr. Joy that hadn't already come out in open court. So he did not have any particular personal reason to not use this letter. He did have a reason to understand that using that letter could make Mr. Clay look bad, as Judge Harris pointed out, and to give the United States an opportunity to, in a way, bolster her testimony, because she would be explaining, I did write that letter, and here's why, because it was my one shred of hope that I could get out. And in that letter, she actually sets forth one of her main reasons is that she, through her conviction, had lost her children. And she blamed herself for misfortune and some terrible things that happened to her daughter while she was in prison. So it also would make her sympathetic to the jury. They would understand why she would want to do this. It wasn't that she lied in her stipulation of facts. It was that she desperately wanted her kids back. And that would have been in front of the jury with this letter. In terms of the prejudice, all of this information came out about her lying, or about her saying that she lied in her plea agreement. It came out through impeachment on cross-examination because we had numerous calls from the jail where she told her husband in recorded calls, the United States pressured me, I don't want to do this, my attorney is making me do this, I'm lying in my stipulation. So she was confronted with all of these statements during cross-examination. So he was able to impeach her as claiming in the past that she lied, claiming in the past that she was unduly influenced by her attorney, and that the United States had pressured her into this plea agreement without having to have the added baggage and burden that would come with this letter. And that's another reason why it wouldn't have mattered. If they had said, you cannot waive this, you get a new attorney, that same baggage that somebody might have influenced her testimony, whether it be his prior attorney or his current attorney, that would still come out in front of the jury if the letter was introduced by any other attorney. Because the United States would have had the opportunity to ask her, why did you write that letter? And whether Mr. Joy is sitting there or another attorney, it's actually going to still come back and potentially reflect badly on Clay, and it's going to at least say he had a prior attorney who might have tampered with the witness.
Counsel, can I ask you a question about the standard of review on this issue about, as I understand your colleague's brief, is one argument on this is that this is an unwaivable conflict. And you say we should review that claim only for plain error. And I'm not getting that, because this seems like an issue that can only come up, I mean, by definition, this question comes up when the defendant wants to waive a conflict and keep his lawyer. And then on appeal, the argument is, well, the district court should not have accepted that waiver of the conflict. And the whole rule is premised on the idea that whatever the defendant is saying, the district court has an independent obligation flowing from the need to protect the integrity of the court system not to accept the defendant's waiver. So how would we be applying plain error here? Like no one has to bring it to the attention of the district court. Indeed, it's the opposite. The issue only arises if the defendant is saying, I don't want you to look at this. And then we say, well, the district court has to anyway. And here, the district court did apply the right standard. The district court addressed this. It said, I don't have to take your waiver. I have an independent obligation. So not only is it sort of logically impossible for the defendant to raise this issue, but the district court addressed the issue. So why would we be applying a plain error review?
Well, I think this is just one of those that plain error review applies when there is no contemporaneous objection.
But it is impossible for this claim to have a contemporaneous objection. That is the point of the claim. I don't. Also, the district court addressed the issue. We always say an issue is not forfeited if the district court addressed it.
Well, even under, assuming we went with plain error review, I think that if something qualifies as an unwaivable error, if it meets this standard that other circuits have put out, that it is so severe and obviously prejudicial, I believe one court described it as the public would be shocked to observe. I think that would be the kind of scenario where you could also show plain error.
That may be another way of looking at it, yes.
You can, it would be an error. It would be, literally the definition is that it's plain on the face of the record. It would be in the interest of justice to recognize that.
That seems like, to me, yet another logical reason, like why are we talking about plain error review? There's no such thing as an error in this context that is not plain. But okay.
And that is one of the complications of this issue. It can be a little circular, just as the court pointed out. But either way, whether you review it under plain error or really any standard, there was no error by the court. The district court applied the correct standard. It accepted the waiver after giving a very thorough colloquy to the defendant. And this conflict was not, it was questionable and really a conservative decision to find that this was even a potential conflict between, because a conflict is a conflict between the defense attorney and the interests of his client. And Mr. Joy would have come out in the same position whether it was in front of the jury during this case or not. So they did not have opposing interests. Either way, they were going to be stuck with the fact that this witness, that the co-defendant, believed this, whether rightly or wrongly. So there wasn't actually a direct conflict in existence, and it certainly was not an actual conflict that would be something that would trigger, something that is unwaivable, is a great concern. And other courts, and this was pointed out in Stanko, this situation, just like it's very difficult to look at it under plain error, it's also difficult to find a situation where a court can win. It is a no-win scenario for courts. They describe it as being whipsawed by error on either side. If he denied the waiver, then he has denied the defendant of his right to counsel of his choice. And if he grants the waiver, he's going to be appealed that it was an unwaivable conflict that he never should have waived. So there certainly can be no error that results in a reversal of the case when the district court applies the correct law, gives a thorough colloquy, and the defendant knowingly, intelligently, and voluntarily waives the potential conflict. If there are no further questions on that issue, in brief, the evidence was more than sufficient to meet the elements of the offense. While this court does not have any published case law on what the scope of the interstate nexus is for sex trafficking. It is a de minimis standard. Congress made a finding that this had a substantial effect on commerce in the aggregate. The way the statute is phrased, it goes to the outer bounds of the Commerce Clause. And in this court, in other contexts, specifically RICO conspiracies, the use of an item that has traveled in interstate commerce is sufficient to meet that. Also, the use of phones, which were used.
So can I just ask you, I understand your colleague's objection on this point to be fairly limited, just factual sufficiency that wireless phone was used. But I was a little bit confused because you argue in your brief that you satisfy the interstate nexus under this effects test for economic activity. And that seems clearly right to me, but that's not how the jury was charged. The jury was charged differently and told, you have to find that the defendant used a cellular network or a car that passed an interstate commerce. Does it matter that the jury wasn't charged under the theory you are propounding?
My understanding is that cell phones, it's sort of been a matter of law that cellular networks are a means and facility of interstate commerce and are channels of commerce.
Yeah, I'm not saying the instruction was wrong. I'm just saying you're making a slightly different argument in your brief, and I'm wondering if I can rely on that even though it wasn't charged to the jury.
I believe you can, Your Honor, because those are really kind of questions of law that would not go to the jury. We don't want individual juries deciding whether a vehicle that travels in interstate commerce can meet that de minimis standard or not. There was also abundant evidence that coercion was applied. The defendant was wearing his full police uniform, including his gun belt, when he assaulted this girl on 2 occasions, once in a very rural, isolated area that he selected, and once in a police station itself. With regards to the Speedy Trial Act, in the most basic level of affirming that, there was a pending motion during that entire time frame. And under the Speedy Trial Act, that alone has told the speedy trial clock until that motion is decided, and it wasn't decided until the day of trial. The hearing was had during the lunch hour on the first day of trial. So from July 15th of 2022, when that motion was filed by the defendant, until the day of trial, the Speedy Trial Act was told.
So the district court was reluctant to rely on that. There's that long footnote where the district court says maybe, but I don't want to rely on that. You think it's clear enough that we could affirm on that ground, notwithstanding the district court's concerns?
I do, Your Honor, because it's a statutory, under the statute, that is an automatic tolling of the time. And the courts have held that when a motion requires a hearing, and 412 motions specifically under the rules of evidence require a hearing, until that hearing is held, the Speedy Trial Act is told. If he had held the hearing 2 days after the motion was filed, then the Speedy Trial Act would have automatically kicked back into play. But it wasn't, and it does not matter what the reason for the delay was. It does not matter whether the delay, or whether the motions would cause the delay. It does not matter how long the delay is under the law. So I believe that the court can rely upon that without even getting into the other issues.
So the motion, for any reason, if it's that tolls it.
It has to be certain types of motions, Your Honor, and I don't think we need to really go into the boundaries of what the outer parameters of that are, because one of the specific ones is a motion that requires a hearing. And this motion in particular absolutely did require an in-camera hearing. So there's no question, that doesn't get pushed into a situation where it's...
So why was it delayed?
I requested that hearing several times, Your Honor, but we are at the discretion of the court.
Discretion of the court?
I requested the hearing twice, Your Honor.
And the court didn't schedule it?
No, not until, I believe, after jury selection.
So in other words, you can extend the Speedy Trial Act by just not having a motion heard. That's your position?
I think that's the Speedy Trial Act's position, Your Honor. And it's, again, entirely at the discretion of the court. This wasn't something where the United States was trying to toll. It was a defense motion, and the United States had no control over when that hearing was set. We requested a hearing. In fact, we had several several different filings where the
What
United
case did you
States.
cite to say that we have no control over that? In
What-
terms of a motion, yeah.
I don't believe I cited a specific case, Your Honor.
But you just
It-
said that there's, so in other words, you can suspend the Speedy Trial Act just by not having a hearing on a motion. That's what you said. You said we have no control. Do we, as an appellate court, have no control either in terms of rectifying that?
Well, there is Supreme Court case law on certain factors. In Henderson, the Supreme Court found that the length or reasonableness of a delay is irrelevant to whether that time is excluded. And in Tinklenberg, it does not matter whether that delay actually, or the pending motion caused that delay. So the statute is automatic, and according to the Supreme Court, even if it seems extremely unreasonable that the court waited a year and a half to hold a motion, despite several requests, the Speedy Trial Act is still told under that statute. So I do not believe there is discretion for a court to find that the delay of the hearing scheduled by the district court means there was a Speedy Trial Act violation. And the final issue.
Otherwise, there was a speedy trial violation here.
I do not believe so, Your Honor. That time was told in an order.
But the
At
court, but the time is not told, there was supersedious, right, indictments?
Yes, Your Honor.
Well, you don't, and that, it may toll it for some of the new counts, but not all the old counts, does it?
Well, the old counts were already told by the court's order. And the superseding indictment did not undo that order. That order does not become negated simply because there is a superseding
Order of
indictment.
what?
Pardon?
What order are you talking about?
The district court entered an order excluding the time from August 23rd until December 13th of 2022, I believe right around August. It entered two orders extending the time and tolling the time. Both were at the defense request because the defense could not get witnesses, could not have availability of witnesses. So that time was excluded, the time period that's challenged of August 23rd to December 13th of 2022. It was previously excluded by an order of the court based upon the defendant's request. And his witnesses were not available.
And your basic point is the court's order can't be countermanded by a grand jury superseding indictment.
That's correct.
When the court says this time is excluded from the Speedy Trial Act, that a grand jury can't countermand that order.
That's correct, Your Honor.
Unless, of course, an appellate court can say it was error for the court to do that, to grant the order.
It is de novo review, Your Honor.
That's right. If it violate the law, yeah, we can.
If the court
If the
finds,
original, that's if the July grant of the 3161H exclusion, if that was an error and your colleague had raised it, which he has not, an appellate court could surely do that, right? That would be a perfectly permissible grounds to object. But what we can't do is say that the grand jury countermands the district court's order under 3161H.
I see that I'm out of time. May I respond, Your Honor?
Sure.
That is correct. If the original order that the district court entered excluding the time from August 23rd to December 13th was in error, that is something the court could reverse. But this court can reverse that, a grand jury cannot. Thank you, Your Honors.
Very briefly, Your Honors, speaking as to the coercion issue,
I'd like to speak to the speedy trial first, since you don't have much
well, I
time.
mean, I think every question that you inquired of is exactly what I would have argued, frankly. There's a case that says that when the superseding indictment that we quoted in our brief, when it came into effect, the previous tolling of the Speedy Trial Act went away.
Wait, what case says that? So I don't see any case that actually says that. So the Fifth Circuit says the opposite. Every other court that's addressed this question says, in effect, that if the district court enters a 3161H order excluding time under the Speedy Trial Act, that a grand jury's indictment cannot countermand that district court's order. that the order excluding time remains valid until the district court or this court says that it's improper, not when a grand jury returns an indictment. So what case do you think supports your view? Because every single case that I've seen, like, very clearly tells us that a grand jury cannot countermand a district court's order.
Well, the motion for new trial and this brief had a case cited in it. I can't give it to you right now, but that was the argument. If that is in fact the case, then there is no argument other than the argument of the extending of the period of time because the district court didn't conduct a hearing.
So what you're representing is that there's a case that adopted your view that a grand jury can countermand a 3161H order by issuing a superseding indictment.
But
That's just, I mean, I can look at it. I'm not, it's in the gotcha game.
all I
I'm
know
not
is
trying to get you to
that I
tell me.
recall right now, as we sit here, a citation applicable to that. Perhaps it didn't say that, I don't know.
Well, the order could only apply to what was existing for the court at that time, right?
Excuse me, Your Honor?
The order that the court made that Judge Richardson is asking about would only be for the charges that existed at that time, right? It couldn't be for something that didn't exist.
Well, that's the point.
Right, that's the point. It's not
No,
that the
that's-
grand jury is changing it.
Yeah.
One is that's a new, it only applies in terms of a new clock there, but it's to,
Well, that's the argument. That's
Right.
the argument we made. Yeah.
But I don't get that. As a matter of common sense, the time was excluded because of the unavailability of a defense witness. Am I remembering right?
That's what I
Okay.
understand,
So
yes.
was that witness not only relevant to the superseded counts? Was the witness not relevant to the remaining counts?
Well, they
remaining
didn't
counts?
limit, I would assume that he was still relevant
Well,
because,
then why would it make any difference that there had been a superseding indictment? I don't understand.
the
I
superseding,
mean, the
indict-
witness was still not available, so I guess the time is excluded.
the witness was not available.
Okay.
Okay. As to the coercion, I don't believe there was any evidence in this trial that Larry Clay coerced the victim.
But the statute specifically doesn't require that. I thought the statute predicated liability on knowledge that the victim was being coerced. You don't have to do it yourself. That's the way the statute's written.
Well,
Intentionally, because Congress has in mind lots and lots of cases where sex workers are being coerced by somebody else.
but there's not even any evidence that the defendant in this case knew the co-defendant was coercing.
Okay.
He didn't even know. And he didn't do any direct coercion. And the government they depended highly upon the fact that he was wearing a uniform.
Well, not just a uniform. The district court was really clear about this. The uniform with all the weapons on it, and then the pushing and the shoving and the ejaculating. I feel like the district court checked off a lot of forms of coercion.
I understand, Your Honor. I understand. Finally, I would like to say that she can understand how Larry Clay and his lawyer didn't have the same perspective, that they did not have opposing interests. I don't know how that's possible when through a hearing the defense counsel has been accused of a crime, or at least a potential crime. And the number one evidence on that is a letter that would help in this case. I don't know how that could possibly be. I thank you.
all right. Thank you. Mr. LaFawn, I note that you're a court appointed. On behalf of the Fourth Circuit, we thank you for the appointment. The Fourth Circuit relies on counsel like yourself to help us in that regard. And we thank you. And Ms. Harrell, we acknowledge your representation of the United States in this matter. With that, we'll ask the clerk to adjourn the court, sine die, and we'll come down and greet counsel.